to you what qualifies as 3 hours of CE credit for core law. I will do about an hour and a half, and then Lori Garland will be with you to focus on her 90-minute segment, which will start after a 15-minute break at 10:30. She will talk about a lot of pending court cases, a lot of court rulings, a lot of interpretations of regulations, true legal matters. What I will be concentrating on are, of course, different things. My part is I'm going to take about 30 minutes, maybe a little bit longer, talking about some very important issues which are going on in Congress at the federal level, both regulatory and statutory. Then I'll switch to what's going on in the Ohio General Assembly, some of the state issues that we're dealing with currently. And then I'll conclude my 90-minute program by talking about giving my best shot at a market overview and some industry trends. Before I start, if you have questions at any point in time, please ask. Just give me the sign and ask the question. I don't want you to, if you want to, you can wait until the end and talk to me later, or you can just call. But I would really encourage you to ask it if something crosses your mind that you need more information on or clarification of. All right, federal legislative issues. Not all these issues fit in what I'm about to say, but some of them do, and the most important ones do. There are two very general themes that kind of answer why some of these issues are at the forefront. By theme, I mean concerns that Congress and the President and the President's administration want to address. And one of those themes is to close whatever loopholes exist to prevent a future meltdown of our financial sector. You know painfully well what that has caused to our economy, and particularly the housing industry. It's been with us now, and we're feeling the effects for something that pretty much started in 2007. That's 4 years ago, under a prior administration. The problems in the financial sector, I'm no expert in what caused it, but what Congress is trying to do is make sure it doesn't happen again. And they did pass legislation which was enacted last year or the year before, called the Dodd-Frank bill, which is a comprehensive attempt to get at, to craft an answer to prevent a future financial sector meltdown. That's one theme. The other theme, which is paramount and should be, most of you probably will agree, is the state of the nation's debt. Spending money hand over fist and steadily, surely, and progressively mounting the federal deficit. So it's measured in the trillions of dollars. And why is it important now? It's important because it's so big, and people are really, the general public is really starting to worry about it, and maybe you are too, because it's unsustainable. And we're going to see on August 2nd the Obama administration and the U.S. Senate and the House's attempt to deal with it just in terms of the issue of raising the debt ceiling. That has to happen, or arguably the United States could default on its obligations. And if that debt ceiling isn't raised, that is the consequence. The struggle, of course, and you hear about it and read about it every day, is that the Republicans in Congress who control the House are insistent that if they, to get their vote to increase the debt ceiling, whatever they do has to include a lot of reductions in expenditures. And that's the problem. There was this group that was put together, and the negotiations were being led by Vice President Biden and several members of the U.S. House and several members of the U.S. Of the Senate and the House. And apparently those negotiations have broken down. And now it's taken up above the rim so that the three participants in these negotiations are the President himself, Harry Reid, who's the President of the Senate, and John Boehner, who is the Speaker of the House. So that's where it all is. Right now the biggest fight is the Democrats are indicating that we'll need to get more revenue in. And let's look at the tax structure. And we'll talk about that issue in much more specifically. But those are the two themes, debt reduction and you might argue, some might say, closing the barn door after the horse has left, but let's prevent another financial sector meltdown if we can. The first federal issue is not a bill. It's a proposed rule. Many of you may have heard of this. I put it first because I think it's the most important. It certainly is the most imminent. What this is it's an outgrowth of Dodd-Frank, the legislation which was passed several years ago. And for those of you who are curious, I kind of was, what exactly does Dodd-Frank say in terms of its preamble? Every bill has like a purpose clause at the beginning. So I looked it up, and this is what it says. The purpose of this legislation is to promote the financial stability of the United States by improving accountability and transparency in the financial system, to end too big to fail, to protect the American taxpayer by ending bailouts, to protect consumers from abusive financial services practices, and for other purposes. That's what it's supposed to do. Sounds good to me. It was analyzed by a law firm in Washington, D.C. I think it was from Washington, D.C. And their take on the legislation is that in order for it to be fully implemented, it will require 243 rules, 67 studies, and 22 periodic reports. That's a lot of implementation. One of the proposed rules of the 243 that are supposed to be adopted is this one. And what this is a definition of qualified residential mortgages, QRM. Why does that have any meaning? Well, I'll tell you why. What Congress is trying to do is prevent the secondary market from being inundated and flooded with risky loans, which go bad and then blow up. And that was one cause of the financial meltdown. There's no question about that. And so what this part of Dodd-Frank says is we're going to put some controls on what banks can sell to another in a secondary market, and depending upon what that looks like, and we'll talk about that too. But if they don't fit the definition, then the banks have to keep them in their portfolio. All right? So the definition is very important. And the definition is a problem. Charlotte. I believe that's correct. Did you hear the question, everybody? That if the loan has to be maintained by the financial institution on their portfolio, the fear is that much higher rates and transactional fees will attach to that potential loan product. Well, that's why I put it first. There's another piece in this, and it just kind of builds on what Charlotte had to say, is the current definition requires 20% down to get this moniker of QRM. And, you know, 20% down is great. I think it's a wonderful thing. It should be encouraged. But well over 60% of recent home buyers, according to the National Association of Realtors, have put down less than 20%, and many of them far less than 20%. Yes, sir?
This does not affect FHA, correct? Or does it?
The QRM, I don't know the answer to that question. It's a good one. It may. There are other things that are being looked at in the context of FHA.
I've just seen some horrible media reports on QRM, and it's sort of devastating to us that people actually leave. We've just scared about 70% of the potential buyers back in.
Well, it's not a final deal.
Oh, I understand that, but the way the media is reporting it is.
Yeah. Well,
It's still 3.5% down.
right.
It's hard to overcome that, but nobody ever talks about FHA in relation to this, and that maybe it's saving grace.
Right. Right. Okay. All right. What is? Where is this? It's not final. It is pending. Comments are being solicited. In fact, the comment period was extended. I don't remember when it was supposed to end, but the comment period now goes to August 1st. What is NAR doing? Well, even though this is a rule, NAR is attempting to get Congress to weigh back in and tell the regulators that this is wrong. 20% is too high. What you need to concentrate on are making sure that legitimate underwriting practices are used when the loan is granted. Check some people's incomes. This crazy no-doc loans, liar loans, this is bizarre. No wonder they went down. Focus on that. Don't give us this onerous 20% down payment. So I'll read you. There's two of these Dear Colleague letters that are going around. What that is, one of them is in the Senate, one is in the House. And by signing on, the congressmen are making a point to Shaw Donovan, Secretary of HUD, Ben Bernanke, you know who he is, Sheila Blair, Chairman of the FDIC, Mary Shapiro, Chairman of the SEC, and a couple of others. And it says, ladies and gentlemen, we the undersigned intended to create a broad exemption from risk retention for historically safe mortgage products when we included the QRM exemption in the Dodd-Frank Wall Street Reform and Consumer Protection Act. And it goes on to say the statute requires documentation of income and assets, debt-to-income ratios and residual income standards, product features that mitigate payment shock, restrictions or prohibitions on non-traditional features like balloon payments and negative amortization, prepayment penalties, and mortgage insurance. Major point in this is the proposed regulation goes beyond the intent and language of the statute by imposing unnecessarily tight down payment restrictions. These restrictions unduly narrow the QRM definition and would necessarily increase consumer costs and reduce access to affordable credit. Then it goes on. This one was signed by Johnny Isaacson. He is a real estate broker from Georgia. Mary Landreau from Louisiana, and Kay Hagan, I'm not where she's from. And there's one in the House as well. So that's where it stands. This is something which is very important. NAR is spending a lot of time on it, and I put it first because it is here and now. I mean, who knows? Maybe these people will take another year to develop a QRM definition, but I doubt it. I doubt it. And maybe it'll drop. Maybe it'll get down to 10%. Maybe it'll get to 5%. Anything is possible, I guess, but it's a major concern, and I think rightly so. Next, kind of related, this is something which comes up periodically. It is the loan limits for FHA and Fannie Mae and Freddie Mac. And they are set to expire. The current limits will expire at the end of September unless Congress acts to reauthorize them. Now, this legislation, which also affects Fannie Mae and Freddie Mac in much different ways, would say, yeah, they should expire. We want to bring them back down to the high of $417,000 and the low of, well, you know better than I what the low is. And that does not make NAR feel very happy. They want to make the current loan limits, which go way up to $717,000, which, you know, around here people say, wow, I mean, why should it be that high? Well, if you live in San Francisco or some of the higher cost parts of the country, that may not be a stretch. But the point here is that they will go back to their prior limit unless Congress acts. And this bill, at least this piece of the bill, would say we're done with this. They're too high already. We want to go back down to where they were before. The sponsor in the Senate is John McCain, and Mr. Hensarling, I believe, is from Texas. Now, you'll see the same bill again. And this is more important than, I think, more important than the first piece that I just described. And that is, what are we going to do about Fannie Mae and Freddie Mac? What should we do? We have to do something. Everybody that you talk to would say we have to do something. I mean, these entities have lost billions and billions and billions of dollars. I think it was like $80 billion, maybe more. And that was a while ago. They may still be losing money. What is the status of them? They're in the equivalent of bankruptcy for a public agency, quasi-public agency. It's called a conservatorship. That's where they are. It's like controls have been put on them through that process. And I don't think there's much doubt that these GSEs somewhere along the way lost their focus. I heard them described as, from their inception, a quasi-private entity with a public purpose. The public purpose mainly being to be an important part of the housing financing system to permit low to moderate income people to buy a home. That's supposed to be their purpose. And then somehow along the way, this individual said they became more of a quasi-public entity with a private purpose, namely to make money. And they were, rightly or wrongly, the recipient of a lot of the risky loans that Congress is trying to discourage against through Dodd-Frank. That's why they lost so much money. So the feeling is you got to do something. These entities are out of control. We can't use taxpayer money over and over again to bail them out. So the question is, what do you do? There was a study that was done that came up with 3 different options. One option, which NAR would like to see happen, is to restructure them. Restructure them, put as many controls and firewalls as you need to make them work, to make sure they don't stray from their public purpose. But don't get rid of them. They're too important. They fear that the possibility exists that if the secondary market goes away, there will be no more 30-year fixed-rate loans. Why should a bank do it? It's not, I mean, that's a long time to get a return that you're, I mean, why would they even do it? I mean, that's kind of, unless they can sell it and make money that way and have investors invest in the bonds and how they're bundled, and I don't know exactly how that works, but that is, that's the NAR position. The second option is to, and I don't know how you do this, haven't taken the time to really look at it that closely, but there was a option that was laid out which said, well, we don't need these entities when the private sector is doing its job, by doing its job lending loans or making loans responsibly and filling the void and all that stuff. But we want to have something in our hip pocket to bring back when the private sector isn't doing its job. Now, I don't know how you do that. How do you have something, I guess a state or a public agency, in existence which is dormant and just kind of sits there and does nothing until the private sector doesn't, until somebody determines that there's a need for them to step in and provide a secondary market when it's necessary. I just don't understand how you could do that. Charlotte. Right. Exactly, and that's why they're doing this QRM stuff, to kind of get at that piece of it. Okay, but then there's a third option, and the third option is to just do away with them, and that's what's in this bill. That's what it would. That's the second piece, or there may be many more pieces to S693 and HR 1182. But a big piece of it is to just gradually phase out Fannie Mae and Freddie Mac until the point comes when they don't exist at all. And that's the option that NAR is most fearful of, and that's probably the number 2 most important federal issue that is out there right now. And there's their position. Okay, let's move to the mortgage interest deduction. I talked about in the attempt to forge a deal to increase the debt ceiling, that some of the House Democrats or maybe the Senate Democrats or maybe the President, I don't know, we're looking at revenue enhancers, closing deductions or restricting deductions, exemptions, what bureaucrats like to call tax expenditures. We're given an exemption, and that's tax that we should receive should that exemption not exist, so it's a tax expenditure. Well, this one fits within the category of what are we going to do to reduce the deficit, obviously. And what occurred, and you probably know it, is that, a couple years ago, the President created a what's it called? National Commission on Fiscal Responsibility and Reform, the Deficit Commission. 14 people, co-chaired by a Republican and a Democrat, very well-respected panel of people representing all kinds of disciplines. And they came up with a report which contained a lot of different things, both on the expenditure side and the revenue side and the tax side. Well, the thing that caught NAR's eye, of course, is what does it recommend for, in particular, the mortgage interest deduction or the deduction for property taxes, things that affect the desirability of holding and owning real estate, particularly residential real estate. And they they gave 3 options for the mid, for the mortgage interest deduction. And one of them, which of course NAR fears the most, is to eliminate it altogether. Eliminate every exemption that exists. Wipe it out. Charitable, property taxes, you know, state and local taxes, mortgage interest, you name it. Wipe them all out and then try and lower the tax rate. Get the tax rate down to 25% or something. The second option is to convert it to a credit. That may or may not work. I don't think NAR likes it, but I don't know why. But a credit's good. Credit's, you know, off the bottom line. And then the second or the third option is to don't eliminate the mortgage interest deduction, but restrict it. The amount of debt that it applies to is too high, $1 million. Reduce it to $500,000. Or eliminate it, or both, or eliminate it for second homes. The argument is if someone can afford a second home, they don't need the mortgage interest deduction. Well, if you live and work in an area which is a resort community and you depend upon individuals buying properties, which could be their second home, you're probably not going to like that. And so that's a big one too. And why is it important? Maybe more important, I think definitely more important now than in the past, is because people care about the debt. And something has got to give. I mean, people who are in Congress or the U.S. Senate or the state legislature, most of them have a very high priority, and that is getting reelected. And if you look at polls, the general populace rates the debt as one of the biggest issues this country is facing. So that's why it's more important now than ever before. It has their attention. And we'll see. Yes, ma'am.
Here's the problem. Here's what I think. NAR and LAR have, you know, you're going against all of these items that Congress is putting forth because they're not good for our industry.
Right.
We need to make changes. Our industry, you know, we're in a situation of physical total debt because some of the things that our industry was accountable for, like all of the debt for the housing market, you know, we took advantage of. I mean, we profited from. My thinking is, why can't NAR and OAR come to a middle ground? You know, maybe that's not a bad idea to have a secondary house, because people that can't afford it might have their secondary house, which is their house that they actually live in now, more than not. That could be their primary house, and their secondary house could be the house that they used to live in.
Right.
I mean, why can't we find a middle ground instead of being totally resistant to everything that they're saying? Because we did get in a mess. I mean, everybody's accountable for it, not just Congress.
No, that's a good point. And I have to make one distinction that, you know, OAR didn't take these positions. NAR did, and they have a process just like we do at the state when we deal with state issues. And we do try, at least at the state level, try and take a much bigger picture and work with the interested parties and come up with something that works. On this, it's interesting you asked that question, because I was at one of the meetings of the National NAR Tax Committee. And I don't go to all of them, and we have some people that are on it. But the purpose of the tax committee at that time was to do just what you said, was to take all of the items, tax-wise at least, that they care about, that realtors care about, and rank them and say, all right, if we got to give something up, what would it be? To try and prioritize and say, you know, we really don't want anything to change, but we understand that we need to be viewed as a constructive player. All right? And I was listening, and all of a sudden, you know, these options were put out there, much like this one, to, well, all right, let's not have it apply to second homes. And you go around the table, and none of them were able to, maybe in your words, take the big picture and say, all right, they weren't even able to prioritize. They weren't even able to put 1, 2, 3. They're all as important. Sure. Well, they do. They do. They will have to. But your point is well taken. All right. So what are they doing? They've done kind of the same thing as they did on that prior, on the rule. There is a Resolution 25, and what Resolution 25 says is, as a co-sponsor of House Resolution 25, I think the mortgage interest deduction is alive and well and shouldn't be touched one bit. That's, of course, not what it says exactly, but that's what its intent is. And there are 140, that's wrong, it's 150, maybe 140, let's say, co-sponsors of House Resolution 25. I listed the ones that are on there to date. Steve Austria is from just west of Dayton. Steve LaTourette's from Lake County in the east of Cleveland. Steve Stivers is from Columbus. Mike Turner's from Dayton, and there's another guy named Bill Johnson who's a freshman Republican from Marietta who's also on this resolution. So we shall see. There is that issue is not going to be decided, I don't think, although anything is possible, in the near future. But it's going to have to be decided, just as an approach will need to be taken to get at the debt, big picture. And I don't know if it'll happen before the election, but by gosh, I mean, if nothing happens and it just continues to rise, I don't think that the American people are going to put up with it. I really don't. So we shall see. All right, short sales. This is a dandy. I know how frustrating that is for all of you who are working with these things, which unfortunately take up such a high percentage of the inventory out there. Either foreclosed, distressed properties is the term I've heard to describe properties that are underwater or are owned by a financial institution. So in order to get the attention of the financial industry to at least respond to legitimate inquiries about a short sale, in went H.R. 1498, the Prompt Decision for Qualification for Short Sale Act of 2011. What does it do? Mortgage servicers must reply to a short sale request within 45 days of a complete submission, and the consequences of not doing so: failure to reply renders the request approved. How about that? Yeah. Well, I don't think this one's going to pass. As much as I might like it to, and you might like it to, it's kind of dormant right now, and what NAR is trying to do is push the sponsor or push the chairman of the House Financial Services Committee to hold a hearing. And let's hear more about it. Bring them in. Tell them why. Let them indicate to us why they can't respond in a timely manner. What is this? Why is this so frustrating? So that's the intent there. It hasn't happened yet. I hope it does, and it might. Spencer Bacchus is the chairman of the House Financial Services Committee. He is very, very supportive of most real estate-related issues. He's a hero to some of the Alabama realtors and their executive officer who know him very well. So we'll see. I think a hearing would be good, because this issue, I know, continues to plague you. Is it getting any better at all? I've heard signs that maybe it has in some ways, but no. No, not better? No? Okay. Yes?
Well, the number of new listings for distress reports has decreased over the last year. I noted a lot of shadow listings.
Yes. If you couldn't hear, Marquet just indicated that the number of properties which fit within that distress definition, or shadow inventory, as they are sometimes called, has gone down, at least in central Ohio. So that's a good thing. That is definitely a good thing, because the effect that it has on property values, regardless of whether the house is underwater or not, is very real. Is very real. Okay. Affordable and available property insurance. This comes up all the time, because this is, again, one of those things that I'll tell you, I hope none of you were in this situation where you were representing a buyer last year, and the buyer qualified for the first time for the tax credit. Clock is ticking. Deal is struck before April 30th or whenever it had to be. The property was located in a floodplain. This flood insurance program expired because Congress let it. All of a sudden, the property is now unmarketable because you can't get flood insurance for it. And that's what happened to some people last year. And can you imagine how frustrating that would have been? Congress went back and reauthorized it retroactively, but by that time, buyer's gone. Seller may have decided not to even try to market the property. Deal's over. And there were a number of people that got caught up in precisely that situation, which is just almost, it's crazy. And it shouldn't happen, but it did. And that's because these things are temporary and they have to be reauthorized. And Congress didn't do it. This, again, flood insurance program, I mean, there are ways where it could be improved, I'm sure of that. The flood maps aren't that great. They've been working on it for years. But you need it. I mean, otherwise these properties are just not going to sell. You just let it go. Sure they do. Oh, they knew it. I knew it. It doesn't make sense to you, does it? It doesn't make sense to me either. But sometimes you get these political games which are played, and this is, I'll talk about another one too. It's called well, this is not a tax extender, of course, but it's expired probably 6-8 times in the last 15 years, I think. And then it gets, I don't have an answer for you. It doesn't make sense to me, and it shouldn't make sense to you. At any rate, NAR is trying to get the thing reauthorized, as they should, and reauthorize it for at least a 5-year period. I mean, give people a break so they don't have to come back and back and back over and over again. This one is kind of along these same lines, leasehold improvements. This too, if you're a commercial broker, you know that the time frame or time period for depreciation of tenant improvements is 15 years. It used to be 39, which is ridiculous. Way too long. So Congress acted and changed it on a temporary basis to 15 years, which is much more in line with reality. This could expire. This came close to expiring last year, and then Congress acted extended it through this year. If nothing happens, then this will go back to 39 years, I think at the end of this year. There are many features of the tax code which are temporary. And I've ticked off about 3 of them, not all tax related. And the answer, what Congress says, is we don't want to make them permanent because by being temporary, it forces us to re-examine their value every now and then and take a look at them and determine whether they should continue. That's their argument. But this one will expire at the end of the year. It will go back to 39 years if Congress does not act. And another reason that can be pointed to when they don't act, as illogical as it may seem, is that it usually takes, these things aren't done on a piecemeal basis. If there's a tax bill, it's usually a fairly comprehensive one. And it would include all these what they call tax extenders. And I asked Linda Gould, who is the principal staff person for NAR's Taxation Committee, what she thought, what's the prognosis? And she was very worried. I mean, I put it up there, she said it's a mess. It's a mess because she can't say with any degree of certainty that there will be any tax bill at all that would include anything. So that's not good.